First to correspondent CB Cotton with the latest. Hi, CB.
Hi, Martha. Yeah, the clock is winding down, and while we wait to see what Trump's next steps are, it appears New York Attorney General Letitia James has laid some of the groundwork for asset seizure should Trump not come up with a bond for nearly $500 million. Earlier this month, James formally registered the staggering judgment against Trump in Westchester County, New York, as you mentioned, which is home to the Trump National Golf Club Westchester and the Trump Organization's Seven Springs estate. Right now, the registration doesn't mean too much, but it is a procedural step that would allow James to secure a lien against properties there in the future. But business law experts tell us James's first steps will likely be...
Most people remember the headline number, $454 million. They remember Trump saying it was impossible to post. They remember the appeals court cutting it down. And they remember him calling it a big victory when he posted the reduced bond. What most people don't remember, because it happened without cameras, without a press conference, and without a single announcement, is that 9 days before that deadline, a clerk in Westchester County, New York, received a filing from the New York Attorney General's office and quietly recorded it in the county property records. No fanfare, no statement. Just a document that from that moment forward made it legally impossible for Donald Trump to sell his golf club or his 212-acre estate without first satisfying a $500 million debt. That filing was not the seizure. It was the preparation for the seizure. And the fact that most people don't know it happened, that the preparation was already in place while Trump's lawyers were still in court arguing that the whole thing was practically impossible, tells you something important about how civil judgment enforcement actually works, and how close this situation came to a fundamentally different outcome. What I want to do in this video is give you the complete mechanical picture, how New York civil law enforcement works, why Letitia James went to Westchester before she went anywhere else, what a lien actually does to a property, why the fire sale option was put on the table, and why Trump's team rejected every version of it, what the appellate division's bond reduction actually resolved, and what it deliberately left intact, and what the fraud finding that 5 appellate judges unanimously upheld means for the permanent legal record, regardless of what happens to the penalty calculation. My name is Matthew John Turner. The judgment is documented. The mechanics matter. Let's go through them precisely.
Trump's bank accounts, stocks, and investment holdings, because seizing real estate is always far more challenging.
You would not want to shut down operations by kicking out employees and such. The property will be most valuable if it continues to operate. I think it would be more like placing a lien against the property so that if he ever tried to sell the property, the state would get its money before he got his money.
Trump's legal team told the court more than 30 insurance companies have refused to accept real estate as collateral to underwrite a bond for the eye-popping total. In response, the Attorney General's office provided a series of suggestions to secure the money, to include a fire sale, but the Trump team has pushed back on all those ideas. Trump has asked the appeals court to accept a smaller bond while he appeals the $454 million judgment, or allow him to not post a bond at all. Martha.
How civil judgment enforcement actually works, and why it's nothing like what most people imagine when a civil court enters a judgment, a formal legal finding that one party owes money to another. The winning party does not receive a check. The judgment is a legal conclusion, not a financial transfer. The winner has established in court that they are owed money. Collecting that money is an entirely separate legal process with its own procedures, timelines, tools, and strategic considerations. This distinction matters enormously for understanding everything that happened in the spring of 2024, because the enforcement process James was navigating is not designed for speed. It is designed for completeness, and the choices she made about where to move first, and in what order, reflect a sophisticated understanding of which enforcement tools work most efficiently against which categories of assets. The first and fastest enforcement tool under New York law is the bank account levy. James's office could serve an execution order, a court document instructing any financial institution holding a Trump account to freeze funds up to the judgment amount and hold them for transfer to the judgment creditor. This requires no additional court approval beyond the original judgment. It requires no asset valuation. It requires no public notice. It requires only identifying which bank holds the account, serving the paperwork, and waiting for the institution to comply. Banks do not negotiate these orders. They receive them, freeze the relevant funds, and process the transfer according to the execution instructions. The second enforcement tool operates on the same principle applied to investment portfolios. Brokerage accounts, stock holdings, securities, all of it subject to the same execution order mechanism. The custodian of the assets receives the order, liquidates or freezes the holdings, and the proceeds go to satisfy the judgment. Again, no separate court proceeding, no valuation dispute, no extended timeline. The mechanism is designed for efficiency precisely because liquid assets are unambiguous in value. The third tool, real estate seizure, is categorically different from the first two. To seize and sell real property, the Attorney General would need to initiate a formal sheriff's sale process. The property must be appraised by an independent expert. The sale must be publicly noticed and advertised, giving potential buyers adequate time to conduct due diligence and participate in the auction. The entire process takes months under the best circumstances. And there is an additional complication that the business law expert in that clip identifies accurately: a functioning property, a golf course generating membership fees and green fees, a hotel with occupancy, a club with employees and operating revenue, is worth meaningfully more as a going concern than as a shuttered building put up for forced sale. Destroying operational value to collect a judgment is not in the creditor's interest. You want the assets sold at the highest possible price, because a higher sale price means the judgment gets satisfied more completely and more quickly. Business law experts who were advising journalists covering this case made the same point consistently during the bond deadline period. James would go after liquid assets first: cash, stocks, investment accounts. Real estate liens served a different strategic purpose, not immediate collection, but prevention of asset flight. If you place a lien on a property before you move to collect through other means, you prevent the debtor from selling the property to raise cash that could then be transferred out of reach. The lien is the lock on the door while you collect through the faster mechanisms operating in parallel. That is precisely what the Westchester filing accomplished. It was not an attempt to seize and sell Trump's golf club or his estate immediately. It was a legal declaration, recorded in the public property records, that any sale of either property would first require satisfying a $500 million debt. Anyone doing title research on Trump National Golf Club Westchester or the Seven Springs estate from March 6, 2024 forward would find that lien on the first page of results. No buyer, no lender, no title insurance company would proceed with a transaction on either property without first resolving it. The properties were functionally locked in place. What Seven Springs actually is, and why the valuation gap matters, I want to spend time on Seven Springs specifically because the property's history with Trump is not incidental to the fraud case. It is one of the central exhibits in it. Seven Springs is a 212-acre estate in Bedford, Westchester County. The main structure is a 60-room mansion built in 1919. Trump purchased the property in 1995 for approximately $7.5 million. For nearly 3 decades after that purchase, he did essentially nothing with it. Various development proposals, a golf course, a luxury housing subdivision, were floated over the years, and each one ran into the same obstacles: local zoning restrictions, environmental review requirements, and sustained opposition from the surrounding community. The estate sat largely undeveloped. What Trump did with Seven Springs was not develop it. What he did with it was use it as a financial instrument, year after year on his statements of financial condition, the annual financial disclosure documents he submitted to banks and insurance companies to secure loans, credit lines, and favorable terms. Trump listed Seven Springs at values ranging from $261 million to $291 million. Independent appraisers brought in as part of the civil fraud trial reviewed the property using standard real estate valuation methodology. Their assessments ranged from $56 million to $110 million, depending on which assumptions about development potential were used. Even under the most optimistic independent appraisal, Seven Springs was worth less than half of Trump's lowest stated value. At his highest stated value, he was claiming the property was worth nearly 5 times what independent experts determined it was actually worth. The Engeron trial found this was not aggressive, but defensible valuation. The fraud finding rests in part on the conclusion that these were not genuine good faith estimates of value with which experts reasonably disagree. They were systematically inflated numbers submitted to financial institutions to obtain benefits those institutions would not have provided at the actual assessed value. The gap between 56 million and 291 million is not a difference in methodology. It is a difference between what the market will bear and what the financial statement said. When James placed the lien on Seven Springs, the irony in that specific choice was precise and visible to anyone paying attention. She placed a $500 million lien on a property whose owner had spent years claiming it was worth hundreds of millions of dollars. Now those claimed valuations were tested against reality in the most direct way possible, a lien that any prospective buyer's title search would surface immediately, making the actual market for the property the operative measure rather than the number on a financial statement. The inflated valuations that had served Trump well in his dealings with banks and insurance companies offered him no protection against a lien that required the actual market price to clear. What the fire sale option actually meant, and why Trump's team rejected every version of it. When Trump's lawyers appeared before the court arguing that posting $454 million was a practical impossibility, 30 insurance companies had declined to underwrite a bond at that amount. Trump's wealth was concentrated in illiquid real estate that could not be quickly converted to cash. The Attorney General's office did not simply accept the impossibility argument. They responded with a set of alternatives, and the fire sale was among them. The concept was operationally straightforward. Trump could begin selling assets immediately at whatever price the market would bear, use the proceeds to satisfy the judgment in real time, and avoid the bond requirement entirely. No insurance company needed. No bond underwriter, just sell the properties, collect the cash, pay the debt. From a pure asset liquidation perspective, this was a legitimate path to resolution. From Trump's perspective, it was a path paved with every variety of financial and reputational risk he had spent decades constructing elaborate legal structures to avoid. The first problem with a fire sale was evidentiary. A forced market sale of Trump's properties would produce market prices. Those prices would enter the public record. If Seven Springs sold at a fire sale for $70 million, which is within the range of the independent appraisals from the trial, that number would permanently exist in the public real estate records of Westchester County. If Mar-a-Lago went at $30 million, consistent with the appraisals that had been presented as evidence of fraud during the trial, that transaction price would follow every subsequent discussion of the property's value forever. Every future negotiation with a lender, every future insurance application, every future financial statement would exist in the shadow of what the open market had actually determined the properties were worth under compulsion. The fire sale prices would be the market's definitive public verdict on the valuations the trial had already established were fictitious. The second problem was architectural, not structural architecture, but the architecture of Trump's public identity and political brand. Mar-a-Lago is not merely a real estate asset on a balance sheet. It is the physical center of Trump's post-presidential political operation, his primary residence, the venue where he held foreign leader dinners during his second administration, and the symbol most closely associated with his persona as a wealthy man of consequence. Selling it under legal compulsion at a fraction of what he had publicly claimed it was worth would be a visible, market-confirmed, permanently documented demonstration of the distance between the financial story he had been telling for 30 years and the reality that independent assessment produced. That demonstration was something his legal team was willing to go to virtually any lengths to avoid. Trump's team rejected every suggestion James made. They took the request to the appellate division, reduced the bond requirement to $100 million, or allowed Trump to pursue the appeal without posting any bond at all. The appellate division's response was split. They did not eliminate the bond requirement. They did not accept $100 million. They cut it to $175 million and gave Trump 10 additional days to post it. Within days of that ruling, Trump posted the bond through Don Hankey, a California auto lending billionaire whose company, Knight Insurance Group, underwrote the obligation. The enforcement mechanism paused. James could not move on the assets while the appeal was pending with the bond in place. The immediate crisis was resolved. Trump called it a big victory on Truth Social. What he did not say in that statement, and what the big victory framing was carefully constructed to obscure, is that the appellate division's bond reduction touched nothing except the immediate enforcement mechanism. The fraud finding was untouched. The underlying disgorgement order of $354 million plus accumulating interest was untouched. The lien on Westchester properties remained in the county records. The court-appointed monitor continued to oversee Trump Organization financial transactions. The appellate review of the penalty amount was still pending. The properties survived. The brand survived. The fraud finding remained on the permanent legal record of the New York court system. The appellate court's August 2025 ruling. What excessive means and what it doesn't. In August 2025, the New York Appellate Division addressed the penalty on its merits and found that the $354 million disgorgement order was excessive under the Eighth Amendment's prohibition on excessive fines. The court vacated the penalty and remanded the case for recalculation. That ruling has been characterized in some coverage as a vindication for Trump, and in some coverage as a technical adjustment that leaves the substance of the case intact. The accurate characterization requires precision about what exactly the court said. All 5 appellate judges who reviewed the case upheld the fraud finding, unanimously. Not a single one found that the fraud had not occurred. The debate among the 5 judges was exclusively about how much money the fraud should cost, not whether fraud had been committed, not whether the evidence supported the trial court's liability determination, not whether the underlying legal conclusions were sound. The fraud is on the permanent record. The 5 judges agreed on that. They disagreed only on the dollar figure. The recalculation is ongoing as of this recording. The final penalty number, whatever it turns out to be, will represent the court's judgment about appropriate disgorgement for a decade of systematic financial statement fraud. That number may be lower than $354 million. It may be substantially lower. What it will not be is 0, because 0 would require finding that no fraud occurred. And 5 judges have already found that it did. The court-appointed monitor. What oversight looks like when a court finds systematic fabrication. One element of the enforcement framework during the bond crisis period that received significantly less attention than the deadline drama was the court-appointed independent monitor that Judge Engoron had installed as part of his remedies order. The monitor's mandate was specific and consequential. Every significant financial transaction conducted by the Trump Organization during the monitored period was subject to review. The purpose was straightforward. A court that has found, after a full trial, that a defendant spent a decade systematically fabricating financial statements does not simply issue a judgment and trust that the same defendant will comply honestly with enforcement orders. The institutional logic of appointing a monitor is that the evidentiary record of the case, the finding of systematic fraud over an extended period, generates a legitimate basis for supervised compliance rather than reliance on good faith. Trump's legal team objected to the monitor throughout the proceedings. The objections were consistently overruled. The monitor filed periodic reports with the court documenting the Trump Organization's financial activities during the enforcement period. Those reports are part of the case record and remain accessible in the public court file. The monitor's existence meant that the public drama of the bond deadline, the insurance company rejections, the Westchester filing, the fire sale negotiations, the appellate motion, was simultaneously unfolding under professional financial oversight. Trump could not, as the business law expert in the clip correctly explained, simply move money to related entities or transfer properties to associated parties to put them out of reach of enforcement. Every meaningful transaction was being observed and documented by an officer of the court. The installation of a monitor is not a routine remedy in civil fraud cases. It reflects a specific judicial finding that the circumstances of the case, systematic, long-duration financial fabrication, warranted a level of oversight that goes beyond the standard enforcement framework. Judge Engoron's decision to include the monitor in the remedies order was a direct consequence of what the trial record showed. Courts do not impose monitored compliance on defendants whose financial conduct they found honest and transparent. The full arc. What 30 years of inflated valuations actually produced. Let me close the analytical section by pulling back to the full picture, because the bond crisis and the appellate maneuvering are episodes within a longer story that the final frame of this transcript captures precisely. Trump's financial statement scheme operated successfully for approximately 3 decades. The mechanism was not complicated. Value your properties at numbers that are substantially higher than what independent market assessment would support. Submit those numbers on annual statements of financial condition to banks and insurance companies. Use the inflated net worth those statements reflect to access loan terms, credit facilities, and insurance coverage that the actual valuations would not have supported. Repeat annually. The scheme worked. It worked because the financial institutions receiving the statements did not conduct independent appraisals before extending credit. They accepted the stated values as a starting point for their own analysis, and by the time independent valuation would have been triggered, the relationship was established and the incentives for the lender to look too carefully had diminished. It worked because the legal risk of civil fraud was, for most of that period, a theoretical background concern rather than an active enforcement priority. And it worked because Trump's public persona as a wealthy real estate developer was itself an asset that made the inflated numbers seem plausible to institutions that wanted to believe their client was as rich as he said he was. The New York civil fraud case did not undo 30 years of financial benefit. The disgorgement order is calibrated to the profits Trump obtained through the fraudulent scheme, not to the total financial benefit derived over the entire period. The lien on the Westchester properties is a consequence of one specific judgment in one specific proceeding. The fire sale that would have produced market prices for those properties on the public record did not happen. The properties remain. The brand remains. But the fraud finding is on the permanent record of the New York court system. The independent appraisals of Seven Springs, Mar-a-Lago, Trump Tower, and the other properties whose stated values the trial established were fabricated. Those appraisals are in the case record alongside the financial statements that departed from them by hundreds of millions of dollars. 5 appellate judges have affirmed that the departure constituted fraud. The penalty is under recalculation. The case continues. The scheme that worked for 30 years produced, in the end, a federally adjudicated fraud finding that no appeal has touched, a lean architecture that remains on Westchester property records, a court monitor whose reports document the compliance period in detail, 30 insurance companies whose refusals to underwrite the bond were themselves a market verdict on the asset quality underlying the stated valuations, and a penalty under judicial recalculation that will eventually produce a final number. The man who ran the scheme is in the White House. The fraud is in the court record. Both of those things are simultaneously true, and the tension between them is the story. Let me state the documented record precisely, because the mechanical complexity of this story makes precision especially important. The established facts. On March 6, 2024, 9 days before the bond deadline, the New York Attorney General's office filed a judgment lien on Trump's Westchester County properties, Trump National Golf Club Westchester and the Seven Springs Estate, in the Westchester County Clerk's office. No press conference, no announcement. A clerk received a document and recorded it. From that moment, both properties were legally encumbered by a $500 million debt that any title search would surface. 30 insurance companies had declined to underwrite a bond at the $454 million judgment amount. The appellate division reduced the bond requirement to $175 million on March 25, 2024. Trump posted it through California auto lender Don Hankey within days. The enforcement paused. In August 2025, all 5 appellate judges upheld the fraud finding unanimously while vacating the penalty as potentially excessive and remanding for recalculation. The penalty amount is still being determined. The fraud finding is not subject to further challenge on the merits. The Seven Springs valuation gap is documented. Trump's financial statements valued the property at up to $291 million. Independent appraisers retained for the trial valued it between $56 million and $110 million. That gap, not a difference of interpretation, but a difference of approximately $180 to $235 million on a single property, is part of the evidentiary basis for the fraud finding that 5 appellate judges affirmed. The fire sale that would have put market prices for Trump's properties on the public record did not happen. The appellate bond reduction made that unnecessary. The properties were not seized. The brand was not destroyed. The claimed valuations were not tested in the open market in the way a forced sale would have required. But here is what the bond reduction, the appellate maneuvering, and the big victory framing did not and cannot change. The fraud finding is in the permanent record of the New York court system. It sits there alongside the independent appraisals that established the gap between what Trump claimed his properties were worth and what the market determined they actually were. That record is not subject to appeal on the merits. It is not going anywhere. Here's the question I want to leave you with, and it is one that cuts directly to the accountability structure we have been examining across this entire series. When a court unanimously finds that a sitting president committed systematic financial fraud over a decade, and the penalty is being recalculated while the fraud finding stands intact, what does it mean for the institutions of financial regulation, civil accountability, and the rule of law that the primary practical consequence so far is a lien on a golf course and a bond posted by a California billionaire?